Hello everyone, it's me, Leonard French, your favorite copyright attorney, back in the US and now in a new studio. So thank you for bearing with me while I get this all put back together. Meanwhile, I have a copyright story for you that is totally bananas, but for some people, it may still have appeal. In the United States District Court for the Southern District of Florida, Joe Morford is suing Maurizio Cattelan, and the court asks, can a banana taped to a wall be art? Must art be beautiful, creative, emotive? A banana taped to a wall may not embody human creativity, but it may evoke some feelings, good or bad. In any event, a banana taped to a wall recalls Marshall McLuhan's definition of art: anything you can get away with. To that end, bananas have come to represent a type of irreverence in pop culture. From vaudeville to Andy Warhol, artists have wielded bananas to expand the boundaries of art. Add to that list Joe Morford, an artist from Glendale, California. In 2000, Morford registered his work, Banana and Orange, with the Copyright Office. While Morford does not allege how widely this work was disseminated, it appears that Banana and Orange was accessible on Morford's website, as well as through social media platforms Facebook and YouTube. In 2019, Maurizio Cattelan also tried his hand at banana-centric art, to much greater recognition. That year, Cattelan introduced his work Comedian at the art fair Art Basel in Miami Beach. The piece was a hit, garnering international press and heralding wide-ranging commentary. Comedian was a financial success too, as Cattelan sold 3 copies of the work, as well as 2 proofs, for over $390,000. Morford now alleges that Cattelan plagiarized and copied Banana and Orange. The 2 works are provided below, with Morford's Banana and Orange on the left and Cattelan's Comedian on the right. For anyone listening by audio, on the left we have a 2-panel piece of artwork. The top panel is a green background that has been sort of taped up on the edges by what looks like masking tape. So you've got like a rectangle of masking tape holding a green panel. And then inside the green panel, there is an orange duct taped to a smaller square of masking tape that is in a little square around the orange. Below that panel is another similar green panel, this time with a banana duct taped to it and no masking tape square. On the right is a similar, maybe substantially similar, duct taped banana without any masking tape or green panel. It's simply a piece of duct tape holding a banana to a wall. Thankfully for the court, the question of whether a banana taped to a wall can be art is more a metaphysical question than a legal one. But the legal question before the court may be just as difficult. Did Morford sufficiently allege in his pleading, in his complaint, that Cattelan's banana infringes his banana? That's a really interesting question, because there's some creativity here, but not a whole lot. So what does copyright protect? Well, copyright's supposed to protect expressions that owe their origins to the author. And copyright will only protect the parts of a work that owes its origins to the author. So is there a novel creative spark in taping a banana to a wall, and does that owe its origins to a particular person, to Morford or to Cattelan? And if there's something that's not protectable, then we have to remove that from the analysis and say that a straight line on a page, that's not protectable. So if somebody makes artwork that's a bunch of straight lines on a page, well, that person doesn't own a straight line on a page. Maybe they own the final piece of artwork that's made up of all their different straight lines on a page. You follow? So what we want to do when we're analyzing this for copyright infringement is first try to figure out, can you really protect a banana duct tape to a wall via copyright? Is there enough original expression there that owes its origins to Morford or to Cattelan? Or has someone done it before, and has it been done enough times that you have to make something new for it to be protected? Let's see what the judge has to say. So we're here on a motion to dismiss standard, and that's important. This is not a decision at the end of a trial. This is not a judgment after a jury has ruled. This is Cattelan, the defendant, trying to get rid of the case at the initial stage. He hasn't even answered the complaint yet. Morford filed his complaint, and Cattelan said, I don't think this complaint is sufficient to go forward. So Morford's complaint is going to get some leeway. The judge is going to say, where at the beginning of the case, Morford doesn't have to prove his case. He just has to sufficiently allege the case. He has to sufficiently connect the facts to a legal claim and ask for some kind of relief. To ultimately succeed on his claim of copyright infringement, Morford must establish 1. The ownership of a valid copyright, and 2. Copying of constituent elements of the work that are original. So again, the protection only attaches to elements that are original to Morford. Copying requires both factual and legal copying. In other words, a plaintiff must show both that the defendant actually used the copyrighted work and that the copied elements are protected expression, such that the appropriation of those elements is legally actionable. First, a plaintiff must show factual copying by either 1. Direct evidence of copying, or 2. Indirect evidence demonstrating that the defendant had access to the copyrighted work, and that there are probative similarities between the allegedly infringing work and the copyrighted work. So a couple different kinds of copyright infringement. Direct copying is direct infringement, but you also have copying of elements that are similar, and if they become substantially similar and you had access to the original work, then you've committed copyright infringement. Now, what if we can't prove access, but the two works are strikingly similar? Another higher legal standard, higher than substantially similar, but lower than direct copying, actual direct copying. Well, if the works are strikingly similar, then we can assume that you had access. I think it's a rebuttable presumption, though, so you might be able to prove that you didn't have access. But if you can't prove it, then we assume that you did have access, and we assume the works are then infringements. Meanwhile, legal copying looks to whether the similarities between the two works extend to the work's original protectable elements. When are two works sufficiently similar? To establish the requisite similarity, courts apply different standards depending on the nature of the allegations. In most cases, courts look to whether substantial similarity exists between the allegedly infringing work and the protectable elements of the copyrighted work. However, where a plaintiff cannot establish the alleged infringer had access to the copyrighted work, the plaintiff must meet a higher standard and show that the works are strikingly similar. Striking similarity exists where the proof of similarity in appearance is so striking that the possibilities of independent creation, coincidence, and prior common sources are, as a practical matter, precluded. The defendant argues that in cases involving a thin copyright, a third standard applies, virtual identity. However, the 11th Circuit has held that the virtual identity standard is limited to claims of compilation copyright infringement, of non-literal elements of a computer program. In all other cases, whether a work has a thin copyright does not affect the standard applied. Rather, it merely denotes that a work has few protectable elements, and necessarily requires that the few protectable elements that exist must share a substantial similarity to the alleged infringing work. So how to determine whether works share a substantial similarity? Courts have developed several names for the elusive test to be applied. The 11th Circuit previously nodded to what we call the extrinsic and extrinsic test. However, the 11th Circuit later opined that this formulation was somewhat of an anomaly. In the Oravec v. Sunny Isles Luxury Ventures case from 2008, the 11th Circuit appeared to return to the lay observer test, which looks to whether an average lay observer would recognize the alleged copy as having been appropriated from the copyrighted works. Now, I have a problem with the lay observer test because the extrinsic test and the intrinsic test, they tried to separate out the non-protectable elements and then only give the protectable elements to the lay observer in the intrinsic test. If you give a lay observer an intrinsic test, and that's pretty much the only test, yeah, they're going to look at a banana on a wall with duct tape and say, oh yeah, those two things look similar. But that's not going to account for the non-protectable elements. That's what I'm concerned about. Let's see how the court deals with that. More recently, the 11th Circuit in the Newman case invoked neither the extrinsic-intrinsic test nor the lay observer test. Instead, it applied the abstraction-filtration comparison test. Ultimately, any disagreement on the appropriate test is more of a matter of semantics than substance. In all cases, no matter the title given to the controlling test, courts must determine whether a reasonable jury could find the works at issue are substantially similar at the level of protected expression. Following Newman, this court will apply the abstraction filtration comparison test. So we're going to get to learn about the new or recent abstraction filtration comparison test. While this test was initially formulated for computer software copyright cases, it comports with Feist's directive to view a copyrighted work in its component pieces and strip away unprotectable elements, ultimately comparing only the work's protected elements to the allegedly infringing work. Feist was the telephone book case, and yes, the abstraction filtration comparison test seems to account for those unprotectable elements the way I was concerned about. Under this formulation, the substantial similarity test now has 3 steps. 1, abstraction, 2, filtration, and 3, comparison. I bet you're very surprised about that. First, abstraction. The court must break down the allegedly infringing work into its constituent structural parts. So this is kind of like the extrinsic test. Second, the court must filter out the unprotectable elements, a notoriously tricky step that depends on the level of abstraction practiced in the first step. So also the intrinsic test, I think. Filtration is built on the fundamental axiom of copyright law that ideas are not protectable. Therefore, fact finders must filter out the underlying idea itself, as well as other unprotectable elements such as processes, facts, public domain information, merger material, and scène à faire material, standard features of a scene, and I would argue fair use material. Last, the court compares the remaining kernels of creative expression in the alleged infringed work to the alleged infringing work. To recap, Morford must plausibly allege. So again, we're at the complaint stage here, so he only has to allege, not prove. Morford must plausibly allege that Cattelan had access to banana and orange, and that, after dissecting banana and orange and stripping or filtering away the non-protectable elements of it, that there is a substantial similarity between the two works. So there's some protected element, and there is a substantial similarity between those protected elements. Before digging in, the court notes that questions of substantial similarity are typically best left to the trier of fact, and not determined by a judge. Deciding questions of infringement at the motion to dismiss stage, let alone at the summary judgment stage, should be approached cautiously. However, where courts only face a visual comparison of the works, and where no discovery or fact-finding is typically necessary, courts will determine whether substantial similarity exists as a matter of law. Therefore, the court will proceed, although the court is mindful that judge-observed similarities and differences between two works are inherently subjective and unreliable, and that unless such similarities and differences render a plaintiff's case bunk as a matter of law, such questions should go to the trier of fact. This is what I was concerned about, and the judge is addressing it, so that's good. That's what I wanted to see. As an initial matter, Cattelan argues that Morford has no valid copyright in banana and orange. First, Cattelan contends that Morford must be stopped from arguing that he has any copyright because Morford has stated in various filings that he does not assert a copyright claim to the idea of a banana duct taped to the wall. Cattelan avers that this amounts to an admission that Morford cannot claim a copyright in his work and that he must be stopped from doing so now. Putting aside the propriety of stopping a pro se plaintiff because of an inartful legal argument, Morford's statement is largely correct. Morford cannot claim copyright in an idea of a banana taped to a wall. However, Morford may be able to claim copyright to the expression of that idea. Second, Cattelan argues that the coordination and arrangement in banana v orange, banana v orange, Second, Cattelan argues that the coordination and arrangement in banana and orange is not sufficiently original to warrant protection. Copyright protection only extends to arrangements that are unique and original. Heralded as the sine qua non of copyright, originality requires consideration of the creativity involved in the arrangement of unprotectable elements, as well as whether the arrangement is firmly rooted in tradition or is too commonplace. I'll give you a quick example. Imagine I make a collage. I'm going to take thousands of images and I'm going to make them into a new image. I'm going to basically paint a picture of my Nico with thousands of collage images. Well, what if I use as my collage source images public domain works? Someone could come in and say, my collage is not copyrighted because it's all based on public domain works. Well, no, I've made something new and original that owes its origins to me, and I've used as a source the public domain works. So I don't own those public domain works, and they aren't now newly copyrighted, but my selection and arrangement of those public domain works is now copyright protected. But judges are not deputized art critics, and the originality bar is appropriately low. Therefore, the requisite level of creativity is extremely low. Even a slight amount will suffice. While using silver duct tape to affix a banana to a wall may not espouse the highest degree of creativity, its absurd and farcical nature meets the minimum degree of creativity needed to qualify as original. While the court cannot and need not give meaning to banana and orange, at this stage the court holds that Morford's choices in giving form to banana and orange are sufficiently original. The court also notes that Morford registered banana and orange with the Copyright Office, which provides additional legal support in favor of the validity of his copyright. So there is a presumption of validity when you register within 5 years. On to the copying analysis. Holding that Morford has a valid copyright in banana and orange, or at least in some elements, the court continues to the next step, whether Morford sufficiently alleged that Cattelan copied the protected elements of banana and orange. But first, the court must decide which standard. Do we use substantial similarity or striking similarity, which depends on whether Morford alleges that Cattelan had access to banana and orange. In his complaint, Morford generally alleged that Cattelan had access to banana and orange. In his opposition to Cattelan's motion to dismiss, Morford expands. Morford argues that banana and orange has been available on YouTube since July 18, 2008, and on Facebook since July 29, 2015, and on his personal website since July 2, 2016. Morford also points to some undisclosed analytics that purport to show that banana and orange has been digitally accessed in 25 countries. Cattelan cites a multitude of cases for the proposition that access cannot be established by mere internet publication. However, all but one of the cases cited were decided later at summary judgment. At the motion to dismiss stage, Morford need not establish that Cattelan had access, but only plausibly allege that he had access. And courts in this district have held that plaintiffs must have the opportunity to establish evidence showing the extent of internet presence in support of access. The other part of this will be that we haven't had an evidentiary discovery or disclosure or hearing or anything at this point. So there's no opportunity for a meritorious plaintiff to get discovery of evidence and have the chance to make their case. Therefore, liberally construing Morford's allegations, the court holds that Morford's allegations that banana and orange was available on multiple websites and access in multiple countries is sufficient to plead access at this time. On to substantial similarity. Finding that Morford has sufficiently alleged access, the court moves on to the substantial similarity analysis. The court starts at the abstraction step, breaking apart banana and orange into its component parts. Morford's banana and orange features two green rectangular panels, each seemingly attached to a vertical wall by masking tape. The panels are stacked on top of one another with a gap between each. Roughly centered on each green panel is a fruit, an orange on the top panel and a banana on the lower panel. The orange is surrounded by masking tape, and a piece of silver duct tape crosses the orange horizontally. the banana is at a slight angle with the banana stalk on the top left pointing up. The banana appears to be fixed to the panel with a piece of silver duct tape running vertically at a slight angle left to right. Next, the filtering step. So abstraction, filtering, comparison. As stated above, no one can claim a copyright in ideas. So Morford cannot claim a copyright in the idea of affixing a banana to a vertical plane using duct tape. And let's also not forget about the merger doctrine. If there's only so many ways to express an idea, then the expressions will merge with the idea and not be protectable. So if there's only so many ways to make a straight line on a page, then nobody gets to own a straight line on a page. That's maybe a bad example of the merger doctrine, but the idea of a straight line on a page merges with the expression a straight line on a page and is not protectable, would be the way it would be said. Nor can Morford claim a copyright in bananas or in duct tape. While Morford is afforded no protection for the idea of a duct tape banana or the individual components of his work, Morford may be able to claim some degree of copyright protection in the selection, coordination, and arrangement of these otherwise unprotectable elements. In particular, Morford can claim some copyright protection in the combination of his choices in color, positioning, and angling. Of course, there are only so many choices an artist can make in colors, positioning, and angling when expressing the idea of a banana taped to a wall. In general, this is called the merger doctrine, where the idea and the expression of that idea merge. However, Cattelan did not argue that the merger doctrine applies, so the court will not consider whether the merger doctrine precludes any finding of infringement here. Well, okay, so that's at least some signposting from the judge. Hey, Cattelan, maybe argue that next time. Last, the comparison step. The court finds at the motion to dismiss stage that Morford sufficiently alleges that there is similarity in the few protected elements of banana and orange. In both works, a single piece of silver duct tape runs upward from left to right at an angle affixing a centered yellow banana angled downward left to right against a wall. In both works, the banana and the duct tape intersect at roughly the midpoints of each, although the duct tape is less centered on the banana in Morford's work than in Comedian. Cattelan argues that the presence of additional elements in banana and orange, namely an orange, the green background, the use of masking tape borders, weigh against a finding of substantial similarity. However, when determining copyright infringement, courts look to the relative portion of the copyrighted work, not the relative portion of the infringing work. In other words, the extent of copying must be accessed with respect to both the quantitative and qualitative significance of the amount copied of the copyrighted work as a whole, which sounds an awful lot like step 3 of the fair use analysis. Here, while banana and orange contains additional elements that Morford does not allege were copied, Morford's duct tape banana constitutes half his work, meaning that it is quantitatively significant to banana and orange. Moreover, given its prominent positioning in banana and orange, Morford's banana is qualitatively significant as well. It's the heart of the work. Therefore, the alleged infringement of Morford's banana is sufficient, both qualitatively and quantitatively, to state a claim. Conclusion. As courts and commentators have recognized, the question of substantial similarity is largely a problem of line drawing, as in, not artist's line drawing, but drawing lines between decisions. Do I go this way or do I go that way? And is this a thin, dark line or is it a thick gray line? At the motion to dismiss stage, the court need not decide exactly where to draw the line, but only that some plausible line exists. Therefore, after application of the abstraction filtration comparison test, the court holds at this stage that Morford has adequately alleged that Cattelan's Comedian has a substantial similarity to the protected elements of banana and orange. For the reasons set out above, the court denies the defendant's motion to dismiss. And that's Judge Robert N. Scola, Jr., July 6, 2022. So we learned a lot about the abstraction comparison filtration test, which sounds an awful lot like the extrinsic-intrinsic test. And that's great, because the lay observer test I thought was a pretty bad test. Also, the judge really, really wants you to know that he's only ruling this way at this stage. How many times did he say, at the motion to dismiss stage, at this time? The judge is making sure that the parties and the public know that the judge is not giving a lot of credence to the level of creativity in Banana and Orange. So if Cattelan continues to defend themselves, then maybe we'll see a ruling in their favor. Let me know what you think of this ridiculous, this bananas copyright story in the comments below. Thanks for watching. Special thanks to my top supporters in the month of July: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Gutbrodj, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all.